people.
Thank you, everyone, for joining us. I'm Elizabeth Reinhart with the Essex Library Association. Today, we have attorney Erin Duques with us. She is from the law firm of Zepega, Daly, Pope & Perry. She specializes in elder care law, and today she'll be talking to you about trusts. If you have questions for the presenter, please drop them in the chat, and we can get to them at the end of the presentation. And we would also appreciate it if you could just stay muted for the presentation so that everyone can hear. And with that, I will hand it over to Attorney Duques.
Okay, thank you, Elizabeth. And welcome everyone to today's presentation. Again, my name is Erin Duques, and I'm an attorney. I focus primarily in the areas of estate planning and elder law. Because we have a small group, if you do have a question and you put it into the chat box, I'll check on it periodically and take some questions periodically throughout the presentation as well as after. I think that's it for housekeeping items because Elizabeth covered them. So to kick it off, presentation. So we'll start with today's presentation is about trust. So we're going to talk a little bit about what a trust is, how it gets created, and why they're used. So the purposes for different types of trusts, as well as some things to be thinking about when you are creating a trust, some of the important components. So a trust is an entity that's created by a written agreement. The agreement is between the parties that you see here on the slide. The grantor is the person making the trust, sometimes can be called settlor. The trustee is the person who is responsible for the trust. So the agreement's between the grantor and the trustee. The trustee has an obligation and responsibilities to the beneficiaries. The beneficiaries are the people who are entitled to benefit from the assets in the trust. So the trust agreement itself explains who all of these parties are, and also would describe how trust assets can be used both during the life of the grantor and then after the grantor passes away. Okay, trust mechanics. So we have different types of trusts. We have what are called, and we'll get into some more detail, but we have living trusts and we have testamentary trusts. A testamentary trust is a trust that's created within a will. So this trust does not get created until after a person passes away. So you would see something to the effect of, I'm leaving everything to my children in equal shares, but I'm leaving it to them in a trust. So when I die, a trust will get created for each of my children, and their share of my estate will get put into that trust for their benefit. A living trust is a trust that you create during your lifetime that exists during lifetime. Distribution provisions, so there's all different types. So you have health, education, maintenance, and support. You can have distribution provisions that discuss keeping the beneficiary living in the manner to which they're accustomed. You can have distribution provisions that say only income will go out to a beneficiary. You can also make it so that the trustee has absolute discretion over whether or not the beneficiary receives distributions. And the reason these distribution provisions are chosen based on the specific circumstances involving the beneficiary. So that's part of what gets discussed with clients when we're talking about whether or not a trust is appropriate for the beneficiaries that they've chosen. And the trust will also spell out who the trustee is during the person's lifetime or after, if it's a testamentary trust, who will serve at that point in time. So different types of trusts. So a common type of trust that you may have heard of is called a revocable living trust. This is a trust. Think of this as a will substitute. So you are creating this trust for the purpose primarily of controlling where assets go after you pass away. So it's used instead of a will. This slide shows you the trust itself. So the bucket is open during lifetime. So for a revocable trust, there's a lot of flexibility. So you're creating the trust, but you can amend it at any time during your life. You can revoke it. You can put assets in and out of it. So you can retitle a house, or you can quit claim a house to it. You can retitle an account and put it in the name of the trust. And then after death, this chest actually closes and becomes locked. And at that point in time, it becomes irrevocable so that it cannot be amended except under very specific circumstances that I'll discuss later. And the assets get distributed out to the beneficiaries in the manner which is set forth in the trust. So either outright to beneficiaries, or it can be in trust for in further trust for beneficiaries. So there's a couple of reasons that people might want to use a living trust or revocable trust. And they're listed here on the screen. So one of the most common, which you've probably heard of, is avoiding probate. So it's avoiding the need to have to involve the probate court in the distribution of a decedent's assets out to their beneficiaries. In Connecticut, we have different probate processes depending on the assets owned by the decedent at the time of their death. Here, when we're talking about avoiding probate, we mainly are referring to the full probate process, which is where a decedent owned more than $40,000 at the time of their death, or real property, so a home. So the probate process can last anywhere from 6 months on, and it can be involved. And a lot of that depends on the nature of the assets and who is in control of the assets, the ability of the executor to get the information they need and file it with the court. There are statutory deadlines involved in the probating of someone's estate. So you have a claims period during which time creditors can come forward and assert claims against the estate. And this period, for 120 days, the estate has to stay open. Nothing can really happen. The executor has to report all of the decedent's assets to the court. They have to get approval for distribution. So there is a process that's involved, which can be avoided using a revocable trust. So we have the living trust is good for out-of-state property, because if you die in Connecticut and you own real estate in another state, you will have to have not only a probate estate here potentially, but you'll also have to have an estate, what's called an ancillary estate, in the state where the real property is located. So that's 2 estates that your executor is going to have to deal with. So that's one reason where we would typically recommend using a living trust instead of a will. A trust can be a good vehicle when somebody owns closely held business interests. In order for the trust to be able to avoid probate, it has to be funded. So assets need to be put into the trust during the person's lifetime by doing things like transferring the property or retitling investment accounts. The assets have to be put in there in order for the benefits of the trust to come into effect. One of the other benefits of a revocable trust is that it keeps affairs private. So what do I mean by that? So when you have a probate estate, your heirs have to get notified of your death, and your will and the probate court filings, for the most part, are public. So anyone can see what assets you had and who you're leaving them to. So for some people, if they have issues within their family, maybe they've disinherited someone, maybe they have nosy neighbors, if they don't want their estate to be public, a living trust avoids probate and keeps affairs private, with the exception of the beneficiaries of the trust. The beneficiaries of the trust, for the most part, are allowed to receive copies of the trust and certain other information about the trust, but it would keep the terms of the trust and information about your assets private from those other parties that I mentioned. So for some people, that can be important. Another reason is for tax planning, estate tax planning. So if a married couple has estate tax exposure in that they own assets greater than what's now 26 million, coming down to 12 million, we may want to include some estate tax planning to try to mitigate their estate tax exposure. That is commonly done under a revocable trust. And then the other reason that a revocable trust can be beneficial for people is if you are leaving assets in trust to a beneficiary. So for example, if you have minor beneficiaries, or if you have a beneficiary who has special needs or substance abuse issues, if you have a beneficiary who you're concerned is going to be getting a divorce, there are ways to protect assets by leaving them in trust for a beneficiary. And that's when that's done under a revocable trust, then that subtrust for the beneficiary does not have to be overseen by the probate court, as it would if it was a testamentary trust created under a will. So that's another benefit to the revocable trust. Just checking on questions. Okay, so other types of trusts. So there are what's called irrevocable trusts. So an irrevocable trust is set up again during your lifetime primarily, and it cannot be revoked or changed. So there are some certain reasons for that, and one is for asset protection. So if in our practice, we are commonly doing asset protection trust, protecting against the costs of long-term care in the future. So care living in the home or care living in a skilled nursing facility. So the way that this is done is the trust is created by the grantor, and assets, primarily a home, is transferred to this trust. And the way that the trust is structured, there is sort of this kind of wall between the grantor and the asset, which creates that protection. So what do I mean by a wall? Well, for number one, the person creating the trust who owned the asset can't be the trustee of the trust. So they have to name somebody else to be responsible for the trust and the assets within it. Now, this person can be a family member, it can be the ultimate beneficiary, it can be a child, but it can't be you. It can't be the person creating the trust. The trust can get, so the way that it works, the way that it protects assets is that if you transfer your, let's say your home into the irrevocable trust, after 5 years, that home is no longer going to be considered your asset for the purposes of determining your financial eligibility for Medicaid or Title 19. That's the 5-year look back rule, probably many people have heard of. So when someone goes to apply for Medicaid, they're going to do a financial audit, and they're going to look to see whether or not you've transferred assets the 5 year prior to your application. As long as an asset or the home is put into the trust 5 years prior, then it is not considered an asset for the applicant. And that's how that's protected. Now, this type of trust would contain distribution provisions very similar to your revocable trust, in that it would say, when this trust terminates, And termination could happen at the time of both after the second spouse dies, or it could happen prior to that, depending on how you want to write the trust, so that, let's say, for example, only one spouse was still living but was in a skilled nursing facility. There's no reason to keep that house in the trust. It can get sold and distributed out to beneficiaries. So that's an option for drafting the trust so that it can be terminated under other conditions besides just death. So one of the other features of this type of a trust is that the trustee can, the grantor can remove and replace a trustee, so they can put someone else in. And so in that way, the grantor maintains indirect control, right? Because if the trustee theoretically isn't doing what they want them to, they can remove and replace them with somebody else. They can also change beneficiaries through what's called a power of appointment, or an exercise of a power of appointment. And one of the other benefits of this type of trust is that it can be drafted so that any income earned by the assets within the trust are still reported on the grantor's tax return. Why is that a good thing? Because typically the grantor's tax rate is going to be lower than the trust rate. So the grantor continues to pay any taxes. Now, when it's a home in the trust, you're not going to have income unless it's rented. But if there are liquid assets, like securities within the trust, then there would be income getting generated within that trust. So why would someone want to go through all this trouble when they could just transfer their house to their son or daughter or someone else and achieve the same goal of getting it out of their name? The reason for that is because when you transfer your home to someone else and you transfer legal title to somebody else, that asset is now theirs. And what that means is that it's subject to whatever may be happening in that person's life. So for example, if they were to get a divorce, if they were to get sued, that asset becomes kind of up for grabs by a creditor. So it puts your asset at risk by transferring it out to somebody else outright. Whereas putting it into this type of trust provides protection against any of the creditors of the ultimate beneficiaries. So someone asked a question about revocable trusts. Does the beneficiary need to have a Social Security number? So I think that's asking, does the beneficiary of the trust need to have a Social Security number? And not that I'm aware of. I think when you have a beneficiary of a retirement account, an institution will ask for a Social Security number, but not that I'm aware of for a trust. All right. So then moving ahead, some other types of trusts that we create for people within our practice. We work with families who have individual family members who have special needs. So there are two types of special needs or supplemental needs trusts. And this first slide shows you the what's called a first party trust. So it's a trust that's created with somebody's own money. So the individual with disabilities may earn some income or may receive SSDI or SSI, or maybe they receive an inheritance from a family member and they have too much money to be able to continue or to become eligible for public benefits. So what they can do is they can create this first party trust and they can put their excess assets into it. And this will keep the assets separate from them so that they can continue to be eligible for means tested benefits. One important feature about this type of trust is that there's a payback provision. So if the individual passes away at some point and there's money still remaining in the trust, then that has to pay back the state of Connecticut for any services or supports that the state paid for on that person's behalf. This type of trust is also referred to as a D4A trust, which is the federal statute. And it also, a couple of other features, it has to be approved by the state of Connecticut. So it has to be submitted to the Department of Social Services. And it can be created by the disabled person or their authorized representative or a parent. There's a number of different people who can create it on the person's behalf. The other type of special needs or supplemental needs trust is, this is the type of trust where an individual, most commonly a parent, might create a trust for a son or daughter or other family member who has special needs and who either is receiving public benefits or may receive public benefits in the future. So in this case, it's being funded with the third party's money. So it's not the money of the individual with the disability, it's the money of the parent or other family member. So it would be something like this, where it would get created potentially under someone's will or as a standalone trust for an individual. And it would say, when I die, my assets go in equal shares to my children, but my son's share is going to go into this supplemental needs trust for him. And a supplemental needs trust has certain specific language that achieves the goal of keeping the assets protected. And that is part of the distribution provisions. So this type of trust would have very specific language that would say that the trustee has the absolute unfettered and sole discretion to make distributions to the beneficiary. And the reason for that is then a creditor, such as the state, can't compel the trustee to make distributions either to the beneficiary or on behalf of the beneficiary. For this type of trust, there is no state payback. So we don't have the payback provision that we have with the type of trust where the individual with disabilities is setting up on their own and putting their own money in. You control, by setting this up, you control what happens to any remaining assets in the trust after the individual dies. So you can say, if my son passes away and there's money left, I'd like the assets to go equally to his children. If he doesn't have children, I'd like it to go back to my other children who are living. So you maintain control over that. Okay. Questions on that? Those different types of trusts. So now we're going to get into some of the kind of specifics about trusts and some of the important things to think about. And one is choosing a trustee. So this can be a very challenging process for clients. I see this happening where, they're on board with creating a trust, particularly for a beneficiary, but then we get to the question of, well, who is going to be the trustee? And it can be challenging. So some of the things to think about. Now, it's kind of a default that people often choose a family member. Sometimes people don't have a family member who they trust or feel confident in this responsibility. Sometimes people may choose a family friend to serve as trustee, and sometimes they might want an independent trustee. So why would you want an independent trustee? That could be, and what do I mean by independent? That could mean a bank, a financial institution, an accountant, an attorney, somebody who's not related or in any way subordinate to the beneficiaries in the trust. Sometimes we use independent trustees for a very specific purpose, such as creditor protection. So if we want to create a trust for a beneficiary and we know that they have financial issues, we would maybe recommend an independent trustee because that will provide the most the strictest or the best creditor protection for that beneficiary to protect the assets in the trust for them. You have the option of choosing a single trustee or co-trustees. So, and just to put it into some context, I'm talking about if you create a revocable, say you create a revocable trust during your lifetime, you would be the trustee of that. But there could come a time in your life if you were to become incapacitated when you would need someone to step in. So there could be, you'd be appointing a trustee for that purpose. When you pass away, your trust needs a trustee to wrap up, to pay any additional expenses, to divide up the assets, and to distribute them in accordance with the trust document. And then if you've created a trust for a beneficiary, you're going to need to have to name trustees to serve in that role. So those are kind of, that's the context. Now you can have you can have one trustee, or you can have multiple trustees. If you have co-trustees, so two or more, unless the trust specifically states otherwise, they will have to act together to bind the trust or to enter into legal transactions for the trust. All trustees will have to sign off on that. Also, it's important to be thinking of backup trustees. So who is going to serve if you've named someone and they can't do it? And that could be for many reasons, right? It could be that they are no longer living. It could be that they decline to serve because they're not, maybe they're ill or they have a lot going on in their own lives and they can't serve. So there are different scenarios for various reasons where someone might not be able to serve and you would want to have a backup named, or a mechanism to name a backup. So that could be having language that says that the majority of beneficiaries can appoint a trustee as a backup, as one example. So when choosing a trustee, here's the things to be thinking about. So when we're talking about specifically a trust for a beneficiary or a subtrust for perhaps a son or daughter, the factors include, is this trust going to end? Or how long is the trust going to last? Is it set up so that it's going to end when they turn a certain age? So when they turn age 25 or when they turn age 40. If that's the case, then you might be able to choose, think about who's in your family, think about the ages of everyone. If it's a minor's trust for someone under 21 or 25, a lot of times someone will appoint the surviving parent. So for example, if I create a trust for my grandchild, if my child predeceases, so I have my grandchild in there as a beneficiary, but I don't want them to receive money outright until they turn a certain age, say 25, I might want to name my daughter-in-law, the child's parent, as the trustee. If it's a trust that's going to continue for lifetime, that might require some additional thought or expertise. The other factors, is there a problem beneficiary? So is the beneficiary you're creating the trust for, do they have substance abuse issues, financial issues, things where, you have to think about, is it really who is best to be relating with this beneficiary? So do you really want a sibling having to be the one in charge of the beneficiary's money? Because that could create issues with their relationship. So that's something to think about. A lot of clients, I feel, tend to naturally gravitate towards naming one child as the beneficiary of the other child's trust. But then as we talk about it more, they realize that that might really become problematic, and they want their kids to, maintain a relationship, be able to maintain a relationship. There are options to name different trustees for different types of assets. There's options to have trustees fulfill certain roles. So you can have one trustee appointed to be responsible for managing are making investment decisions regarding the assets in the trust. You can have a different trustee who's going to be making the decisions about how assets are going to get distributed. So for example, if you have a trust for a beneficiary that says distributions can be made for the beneficiary's health, education, maintenance, and support, well, the trustee is going to have to make decisions along the way about distributions that fulfill those standards. And so there might be one trustee better suited for those types of decision making, but you prefer to have someone else be responsible for the investment decisions. And then family members versus professionals. And so that's what I was discussing a little bit before about if you have an independent trustee, that person's going to have, or that professional is going to have the ability to say yes and no to the beneficiary a little bit better than perhaps a family member. How long is the trust going to last, and what is the life expectancy of the beneficiary versus the trustee? So if you have a young beneficiary and you're naming your sister or brother who's about your age as the trustee, then you're probably going to want to be thinking of a backup, because it's likely that if you've passed away, that trustee is also going to be may not be living at the time of the trust creation as well. Things like, what are the complexity of the trust assets? So what's going into the trust? Is it, it could be rental properties, it could be business interests. Depending on how complex those assets are, that may impact your ability of, your decision rather on who's going to serve as trustee. If you're choosing, if they are complicated assets, you may want someone, a professional, to serve in that role. Now, keep in mind that a trustee does not have to be, has to be financially competent and responsible, but doesn't have to be, an expert in investing, because a trustee, while they have the ultimate responsibility to manage and the assets in the trust, they are going to be most likely hiring or looking to other professionals, just like any of us would, like a financial planner or advisor, an accountant, to make sure that the assets are handled and managed correctly. And that's perfectly fine. So sometimes I see people getting caught up in that. If they have a potential trustee who's, not necessarily in the finances world, for example, that's okay, because they're going to be working with other people with expertise. When you're looking at considering an independent trustee and you're considering a bank, for example, or a financial institution, you're going to want to be thinking about, or if you interview a bank or other institution, one of the questions to ask is, who is my beneficiary going to be interfacing with? Who are they, if they call because they need a distribution, they want to buy a new house or something, who are they going to be dealing with? That's important. That's important to know. And then it's important to think ahead. So like, let's say you've got your first line of trustees named and you're feeling confident. And then it's good to start thinking about, well, what if they can't serve, as I talked about before? So naming backups. Also, what if something happens and there's a valid reason for the person to be removed as trustee? So again, during your lifetime, you can remove and replace trustees, or you can amend your trust to take people out. But what if a trust is in existence for, what if you become incapacitated? Or what if a trust has been created for one of your beneficiaries and there's an issue with the person serving as trustee? The trust should really, excuse me, the trust should really address how the person, if and how the trustee can get removed. Can they get removed by a majority of the beneficiaries? Or should it be that it's a unanimous decision by beneficiaries? Can it be removed for any purpose? or just for, for reasons, specific reasons that they can be removed. If they can be removed, who can they be replaced with? So should they be replaced with someone independent? So for example, I create a trust for my son and I give my son the ability to remove the trustee. That's fine. But I might include language that says, but they have to replace that person with someone independent. So in other words, they can't replace the trustee with their best friend who will be more likely to make distributions to them. There should also be within the trust, there's typically language that addresses what happens if there are vacancies. So what happens if you've named your trustee and you've named your backup, but they're unable to serve, both of them. How can vacancies get filled? And perhaps, again, that's by a unanimous vote of the beneficiaries. Perhaps you have a trust protector who can appoint or fill a vacancy. There's always the court. So the court is always the backup. They can remove trustees, they can fill vacancies, but when you leave that up to the court, you're taking away your ability to control who would be able to serve in those roles, because the court can appoint who they want to do that. Okay, I'm going to pause here just to answer a couple of questions. Can a trust be used in place of a power of attorney? So a trustee and a power of attorney or agent under a power of attorney are similar in that they're fiduciaries, but they're responsible for different things. So your trustee is going to be responsible for the assets within the trust. That's what your trustee has power over. And that can be really important if you have a revocable trust and you become incapacitated. Your co-trustee, so maybe your spouse, or if you don't have a co-trustee, your successor trustee can easily step in and take control of those assets. So incapacity planning is another benefit of the trust. The power of attorney can be much, much broader than that. So your power of attorney is going to be responsible for other assets, so non-trust assets, as well as many other aspects of your life, with the exception of healthcare. So being able to do things like access your email if you choose to give them that power, check your mail, access your safe deposit box, call Social Security. All of those things all of those are going to be jobs that a power of attorney would have the ability to do. So not your trustee. Can the trustee draw from the trust? So the trustee can only make distributions from trust assets to beneficiaries. The trustee can pay expenses of the trust, and that would be spelled out in the trust document. So how can the money be drawn to pay invoices? So the trustee would set up a trust account, so a bank account, and be able to pay expenses out of that account that's held in the name of the trust. Okay, some of the powers of the trustee. So the powers of trustees are spelled out in the statutes. They are also in the Uniform Trust Code, which I'm going to talk about in a few minutes. But the powers, they have very broad powers to do, to manage the assets in the trust. We have here is an independent trustee needed. I've talked about sometimes you may require or you might want a trustee, an independent trustee. Should there be a trust protector? Trust protector is a concept under common law, which allows someone to be appointed should there be a need to, under very specific circumstances. So for example, if a trust needs to be amended or if a trustee needs to be removed, you can have an independent person serve as a trust protector to do those things. So those are all options that would be within the trust document if they applied or if they were desired in your particular situation. So the Uniform Trust Codes, this was adopted by the state of Connecticut, became effective after January 1st, 2020. So 35 states have adopted some form of the Uniform Trust Code. And what it does is it establishes a set of rules that the trustee has to follow. Some of the rules are they serve as default rules. So in other words, if your trust document doesn't address certain things, then the Connecticut statutes is going to become the default. So from that perspective, it's important if you have a trust that was set up prior to 2020 to have it reviewed by an attorney to see how it works with the current trust, the Uniform Trust Code. The Uniform Trust Code is going to apply to trusts that become irrevocable after 2020. That means if you've created a revocable trust prior to 2020, when you pass away at some point, the Uniform Trust Code is going to, or the Connecticut Trust Code is going to apply. If you create an irrevocable trust after 2020, again, the Uniform Trust Code is going to apply. Some of the rules created by the Uniform Trust Code are mandatory. In other words, they cannot be overwritten by the terms of the trust. And these are things like the duty of loyalty. So a trustee has a duty to act with loyalty toward the beneficiaries in the best interests of the beneficiaries. They have to administer the trust as a prudent investor. They have to act in good faith. They have to keep the beneficiaries informed. So this is a new aspect of the law, which is very important. It gives the beneficiaries the right to be informed during specific stages in the trust, the creation of the trust, and then the administration of the trust. So when a trust gets created and becomes irrevocable, the beneficiaries of the trust have to get notified that this trust has been created and that they are the beneficiaries of it. They are entitled to ask for a copy of the trust. They're entitled to get notice when a trustee resigns and when a new trustee takes over. They're also entitled to receive information about what's in the trust. So annual financial reports, so that the beneficiary, can review the reports and stay on top of what the trustee is doing with regard to the assets in the trust. And that's a way to kind of keep an eye on the trustee. So these are important changes. Now they're not so new because it's 2024, but they are changes that may impact trusts that were created prior to the law. It's always a good idea to have older trusts just reviewed within the context of these new rules. Non-mandatory. So there are certain rules that you can override in the trust document. So provisions regarding trustee removal, you can have the ability to craft your document so that it addresses that the way you want. There's a presumption that if you have co-trustees, they have to act by majority rule. You can write it so that trustees can act severally. So in other words, any of the trustees can bind the trust. And so sometimes for convenience purposes, you might want to do that instead of requiring everyone to have to sign off on everything. So it's important if your trust is silent on something that you are okay with the default that's written within the statute. All right. What can the grantor do to protect the assets if the trustee or trustees might take assets for themselves? So, during the grantor's lifetime, the grantor is typically going to be the trustee, but if they're not the trustee, they're entitled to reports about the trust. So, or their power of attorney. Their power of attorney may also be able to access that information. So that's in that way they can keep track of what the trustee is doing. The provisions that I just mentioned having to do with informing a beneficiary, the purpose of those is so that the beneficiary again can can have the ability, can have the information necessary in order to be able to make sure the trustee is doing what the trustee is supposed to be doing. So what can they do to protect the assets? I mean, really, you want, when you're naming a trustee of your trust, again, this goes back to being very, very careful and considerate about who you're serving as, or who you're choosing rather to serve as trustee, because you want it to be someone who is competent, someone you can trust. There are the abilities, like I said, to remove a trustee if they're not doing what they're supposed to be doing. And they're also, as a fiduciary, they, they can be held liable for using trust assets improperly. And that would be through the probate court. So the fees. So sometimes people ask, well, what can fiduciaries be paid, or what can trustees be paid? So the law is not, it is a little bit fuzzy on it. What the law says is that the fees have to be reasonable. And there was a Connecticut Supreme Court that helped with defining what reasonable means. And so it's fees that are when fees are being considered, you have to consider a number of different factors, such as what is the size of the estate, how much work is involved with the estate assets, are there special problems or difficulties, does it require specific knowledge or skills, for example, tax knowledge, tax expertise. So those would factor into the fee that the trustee could charge. There's no statute that defines how much someone can charge for a fee. And the fees can always be over, if a beneficiary questions the fees, they can always involve the court to take a look at what the fees that the trustee is charging. Certain duties under the statutes for trustees, as I discussed earlier, these are the duties by the statutes. So a trustee really has an obligation to act on the best in the best interest of the beneficiary. They owe a fiduciary responsibility to not just if there are multiple beneficiaries, to all of them. And that's important. Okay. Sure what happened there. I think we're at the end there. Does anyone have any other questions for me? Here's my information. You have my email here, so you're welcome to email me with questions. There's my phone number as well. So it doesn't look like there's anything else, Elizabeth, as far as questions.
Okay. Thank you so much for providing such an informative presentation, Erin. We really
You're
enjoyed
welcome.
it. Thank
You're
you.
welcome. Thanks for having me.
We hope you'll return sometime soon.
Absolutely. Enjoy your day.
Could you go back to the very beginning, the first few?
Oh.
The first few frames.
This presentation will be uploaded to the library's YouTube channel as well, in case you missed anything.
Oh, good.
And I'll send that link out after it's uploaded.
Oh, good. Thank you.
Okay.
Yeah.
Did you have a specific question? Or
no, I just missed the very beginning.
Oh, okay. Okay, good. Yeah, so that will be available.
Oh, good. How
Okay.
do I get it?
I'm going to email the link out to everyone who registered.
Oh, great. Thank you.
Sherry has a question. Go ahead and type it into the chat, Sherry.
Hmm.
May a grantor use assets after they have been put in a trust?
So it depends on what type of trust it is. So if it is a revocable trust, then yes, you have full access to those assets. If it's an irrevocable trust, like I mentioned before, for asset protection. So if you're doing it to protect assets in case you need long-term care in the future. As I mentioned, there needs to be like this theoretical wall between you and the asset. So if you put an asset into an irrevocable trust for that purpose, you cannot be the trustee, so you can't have control over the asset, and you can't be a beneficiary. And that's why a house is a typical asset for that type of planning, because you maintain the right to continue living in the house. But you wouldn't be putting liquid assets into an irrevocable trust if you are anticipating that you would need to live off them, because again, you can't be a beneficiary. Anything else? I think we're good.
Okay.
All right.
Thanks again, Erin.
Take care. Yes, thank you all.
Have a great day.
You too.